The committee meeting is going to be recorded and broadcast throughout Parliament buildings and online, as it usually is. Everybody in the public gallery is welcome and they can use their mobile devices provided they're in airplane mode and everything is muted. If anybody needs to connect to the Wi-Fi, the password there is in the gallery rules. It's not permitted to take photographs or record any of the meeting, but I think since we only have officials, nobody needs to worry about that. It's proposed, members, that the oral evidence session on the Justice Bill with officials from the Department of Justice will be recorded by Hansard. Are members agreed?
Agreed.
Thank you. Members, every week we're obliged to declare financial or other relevant interests that might be reasonably thought by others to influence our approach to matters under consideration. Anybody who's got an interest to declare in relation to today's proceedings should do so now or when the particular matter arises. Does anybody have anything? Deirdre?
Immediate family member works in the court service.
Thank you. And my usual one too, where I have an immediate family member who works in the legal profession. Agenda item 3 is draft minutes. Could I ask you to turn to pages 22 to 31 of your meeting pack, where you'll find minutes of our last meeting held on the 16th of January. Are members content that those are a true and accurate reflection of the proceedings of that meeting?
Agreed.
Yes, thank you. Then I'll sign them. Agenda item 4 is matters arising, and there are a few things here. I would ask you to turn to pages 33 to 43 of your meeting pack for the relevant papers. At our meeting on the 12th of December, the committee considered correspondence from K9 Search and Rescue Northern Ireland requesting that the committee seek clarity on the decision by the department not to approve its application to join the Northern Ireland Search and Rescue Practitioners Group. At that meeting, the committee agreed to ask the department for clarification on the reasons for declining the application and a number of other questions. Then, at last week's meeting, the committee considered an item of correspondence that referred to K9 Search and Rescue Northern Ireland and that raised a number of issues. At that meeting, the committee agreed to consider this item of correspondence further when the committee had received response from its initial letter to the department. So you'll see now that the department has responded and that response has been included in our packs. First of all, can I seek your agreement to forward the department's response to K9 Search and Rescue?
Yep.
Yes, members agreed, thank you. It also may be helpful, I think, in that circumstance, because I suspect that K9 will have received a lot of that documentation already for their appeal purposes. So it may be helpful for them to have sight of what was actually sent to the department from us. Are members content with that too?
Yep.
Thank you. Now, with regard to this whole issue, members, does anybody have any views on how to proceed? Ciara?
This is just my personal thought, to be honest. In reading all the correspondence last night, I'm really uncomfortable with regarding the application process, and specifically with regards to practitioner group, where you have your statutory organisations, you have your community and voluntary organisations, but many of them are, I don't know, are they being commissioned? Is it a grant process? Is it an application process? Is it a procurement process to deliver a service? It's outside my comfort zone from what I'm used to and working in the community and voluntary sector. I think it might be useful in relation to getting clarity. Is there precedence elsewhere in relation to this model that's been taken forward? I'm not familiar with.
I think we can ask. Some of the concerns that I had with regard to the process were, it seems that if somebody has an organisation, they can apply, and then that practitioners group or the statutory side of it can determine whether or not there's a need. I'm slightly worried about that. I'm not clear that it isn't a closed shop. And I think I would like some reassurance that it isn't. Because I imagine if I were in circumstances where somebody that I loved was missing, you would want all available resources.
Likewise, I think the department, I didn't get an enabling environment within the current setup where you should be enabling, just even in relation to if you've been tasked by a statutory body, you can become an associate member, but you're not eligible to apply for funding and stuff. So I think we should be enabling as many organisations working in this field as and when required, no matter if it's regional or local. So I would like to see an enabling environment and how we encourage and support. And is there any precedence in relation to this current setup? It's just, I'm uncomfortable with it. And someone who's worked in the community voluntary sector 25 years, I've never come across this model. So.
Yes.
And I don't know the group, and I have not met the group.
No.
I just put that on the record as well.
No, and I think it's one of those ones too. Like it's a very specialist area of work, and certainly I'm familiar with in previous searches when entire communities came out to try and search, particularly for children. There's always the issue around damaging evidence and all of that. So there are a lot of factors to take into account, but I don't think there's any harm in us understanding the process and seeing how it works and asking the questions that you've raised and the questions that I have raised. So are members content that we would do that? Thank you. With regard to the other piece of correspondence that came in, the department already has that. It was circulated to them. So I don't think there's anything more that we need to do on that front. Unless anybody else has any suggestions.
Probably we just noted them.
Okay, members content to note that then. Ciara.
Just one other thing. Is it possible to get in a copy of the needs analysis that does be done and how often it be done by this group of practitioners? Because I think it might be quite useful as well.
Yes.
Just to know what the current needs analysis is across the north.
Yep, members agreed to add all that in?
Great, yeah.
Thank you. So that's that one. Then item 4.2 is correspondence from the Bar of Northern Ireland. That's at page 44 of your pack. So the Bar has written to the committee to request that the written paper from the Minister of Justice on the Enabling Access to Justice Reform Programme, which the committee considered at last week's meeting, be shared with it. Do members have any views on that? Are you content to share that written paper with the Bar?
Yeah, content, yeah.
Public, yeah.
Well, if we're going to share it with the Bar, I think that it would be fair and equitable then to share it with the rest of the profession.
Yeah.
So on that basis, I would also propose, if we're going to share it with the Bar, we would also share it with the Law Society and the Solicitors Criminal Bar Association. Are members agreed to that?
Agreed, yeah.
Okay, thank you. Then lastly, I think, in terms of matters arising, is correspondence at item 4.2, which is correspondence from McGibbon Consultancy and Safeguarding Services. So we discussed this last week. It's at pages 45 to 55 of your pack. At last week's meeting, we considered an item of correspondence from McGibbon Consultancy and Safeguarding Services, and it was requesting that the committee raise with the Minister of Justice, the Department of Justice and the constituent agencies of public protection arrangements in Northern Ireland a number of matters regarding a murder case and the lack of a serious case review. So we had agreed to consider this matter further after I shared with the committee further items of correspondence that the Deputy Chair and I had received in relation to it. So you've all received that now. I presume you've had a look at it, and you can see the various action points the Minister had agreed to take on, some actions. There was a response to that seeking a broader scope. The Minister replied again saying that she had reconsidered and would widen it out, but I think there's a further request to broaden it beyond justice. Does anybody have any views about this, Deirdre?
Yeah, no, and I know we kind of deferred some of this from last week just to give everybody the chance to have it. So I suppose that, I mean, I've met with the individual who's corresponded, so I suppose just to put that out there as well. But I would like further information from the department around the terms of reference, because as you say, in different iterations from the Minister, she obviously responded to this in the chamber, that she's taken it serious, and that was initially to be a review by the two lay members who are part of the public protection arrangements that then changed in the subsequent correspondence. So I would like to be furnished with the terms of reference and the status of the review. So obviously, I know the Minister had said previously why it wouldn't be a serious case review because, you know, it hadn't been referred into the public protection arrangements previously. So I would like to know the status of the review, the terms of reference, who is going to be carrying out that review now and what expertise in safeguarding they have, because I'm conscious the lay members, be it they do a good role, but do they come from that background in terms of safeguarding? Is that their specialism and expertise in order to conduct a review? And I think the other bits for me, I would be concerned if this review was only looking at the justice element,
Yep.
because a huge part of this case goes into health. The
Yep.
fact that in terms of the deceased had went 18 times within a 2-year period, that's nearly once a month, with the individual actually accompanying her. And the fact that there was no red flag in that scenario. So when you look at the external serious case review, they look across all of the departments and agencies that fall under the broad safeguarding board, which would be health, it would be justice as well. There was obviously, even when he got out of prison, the prison service also. So is the review as part of the terms of reference going to cover all of that to include health and others? And my other concern as well, that it's easy just to kind of focus this on the deceased. But there were other people, my understanding is when this did go to court as well, there were other young people that at some point, now nothing might have materialised, there mightn't have been risks, but we don't know that. And is the review in which the Minister's going to do, going to take in terms of double checking all of those and to ensure that the proper process was in place? So were there potential risks with those other young people or vulnerable people in which this person had interacted with, be that even their own children and stuff as well, and is that going to be considered and not just the individual who obviously was murdered? So I think there's a couple of things. So I think the terms of reference and to kind of ask just further clarification, and I mean this could all be considered, but obviously we don't know at this point, so I would like more information around all of that if it's possible.
Yeah, that's fair enough. I think that there's a couple of points. I'm not clear that it's in the Minister's VARES to extend into health. We can check that, and it may well be that maybe we should, with the correspondence permission, copy some of this to the Committee for Health and the Department for Health to see what input they could or should have, because the thing, I mean, I suppose the justice side of this is focusing on how the perpetrator managed to slip through the net, but the other side of it is, well, the victim here, how did she slip through the net? And as you say then, everybody else that's tied in there, so it's beyond. So I think there's no doubt our members are content to send that letter to our department, but in terms of scoping out the terms of reference and how it relates to other safeguarding institutions, including the Department for Health, what do you want to send this to the Department for Health and the Committee for Health?
Yeah, I think it would make sense.
I'd be happy to,
Yeah.
I mean, I presume we'll need to check that with the person with McGibbon Consultants, but Deirdre.
I'd also be keen, because we've obviously been told, or it was in correspondence, that the serious case review can't be done, because that would take all those different departments, that would look across all the safeguarding agencies, and you'd rather just do it once than having to do different agencies doing their own thing. So is there anything in law to say that it can't be done? I would like a bit of clarity on that around, I mean, we've been told that the serious case review doesn't happen in this because it was never referred in to begin with.
Yeah.
But is that in law? Is that, or could there be an exception in terms of the public interest in this case? So just even a bit of clarity on that, and then yes, Chair, just your proposal of sharing it with Health Committee, I think would be good.
So our members, Cathy, do you want to
can I just check now, Chair? The letter to the Department of Justice seeking all the information, do you want to also include that with the information that goes to the Department of Health?
So, sorry, the information,
So the information
sent back
that the
yeah.
committee is requesting, so the letter to the Department of Justice, do you want to also include that to the Department of Health and say this is the information we're seeking from Justice, but we also believe that it's relevant to the Department of Health?
Mm-hmm.
Take that approach maybe?
I think so. I think it's important that everybody's aware of exactly what's going on everywhere with this, because what happened was that people fell between the stools and between the cracks. So let's not do the same thing again whenever we're trying to find out what's going on.
Yeah.
Deirdre?
I think it's just, I mean, the Minister could be doing all of this, and unless, and maybe we just don't know. And I know obviously she's taken it serious, but it is, as you say, it did fall through the cracks in the previous year. So just to make sure that we all learn from it going forward, and trying to make sure it doesn't happen again.
Well, I'm sure the Minister will, and has been liaising with the Minister for Health, but let's just check and make sure. Thank you. Agenda item 5 then is the Justice Bill. So we have, let's see, we're looking at the amendments. So that's Reform of Rehabilitation Periods, Repeal of Vagrancy Legislation, and Live Links, Courts and Tribunals, Department of Justice, Oral Evidence. I'd ask members to turn to pages 56 to 95 of our packs, and that's where you'll find the relevant papers. So we have departmental officials with us again today to provide oral evidence. The amendments relate to the areas of the bill that I've outlined, and I would welcome Andrew Laverty, the bill manager. Andrew, nice to see you again. Long time no see from last week. Maura Campbell, the senior sponsor of the bill. Lorraine Ferguson-Coote, who is the head of the Criminal Policy Unit, and Mara Shane, who's the head of the Legacy Policy and Legislation Group. So, folks, you're all very welcome. Thank you for taking the time. Mara, can I check that I have pronounced your name correctly? Is that
Myra?
Mara? That's great. Thank you. I just want to make sure there's nothing worse than referring to somebody as the wrong name throughout.
I've answered to many things.
Me too. Provided it's within common decency and the bounds of the law, then we're fine. Right. So I'm going to hand over to you folks then. Thank you very much for your attendance today. We welcome it. We look forward to hearing from you, and then we'll take questions. I would propose that, as we did last week, we deal with it in sections. So if we can work through the rehabilitation periods first, and then deal with questions on that, and then move on to vagrancy, and then head into life links. Does that work for you guys? That's great. It saves us jumping about, and it's a bit more of a coherent approach. So thank you very much. Over to you.
So, Chair, we worked Andrew quite hard last week, as you know, so I was going to kick off this time around. So you'll recall he was here with relevant colleagues to brief you on some of the Department's planned amendments on the Justice Bill, and today's covering the remainder. As you say, it's rehabilitation of offenders, vagrancy, live links and courts and tribunals. All of these are areas that fall within our own division, and I'm joined today by the respective policy leads from within our team. And you have the written briefing. I was just going to very briefly summarise the 3 areas and then just hand over to policy leads as we go through each section as you've suggested. So briefly summarising, firstly, the rehabilitation of offenders provisions would bring forward amendments to the Rehabilitation of Offenders Northern Ireland Order 1978 to reduce the length of time that it takes for some sentences to become spent and to allow for more convictions to be capable of becoming spent. Then secondly, we have the vagrancy amendments, which would repeal the current rather archaic vagrancy legislation insofar as it would decriminalise rough sleeping and begging in Northern Ireland. We'd instead rely on a range of other offences that are available to deal with public order, disorderly behaviour and harassment in public places where someone's actions breach the threshold of criminal behaviour. And then finally, the live links provisions that are intended to provide a long-term legislative solution to allow for the wider use of live links as part of the Northern Ireland Courts and Tribunal Services Digital Modernisation Programme. So I think we're starting then with rehabilitation of offenders. That's over to Andy.
Yeah, well, I mean, Maura summarised the principal policy intent of the amendment, so I'm quite happy that feel free to ask any questions that you might have.
Off we go, we're straight in. Okay, who's coming up first on that? Me? Right. My stuff is fairly straightforward in this. Andrew, let me just get to the right page. I'm going to page 67 and I'm on paragraph 10 of your report. No, that's not right. Sorry. There's a table in there. I'm just trying to find it. Yes. Page 66, apologies, page 66. My question is there, I have a few questions around this. I'm keen to understand what happens after, with a sentence that's over 10 years. Mm-hmm. Then beyond that, there's reference in this to there are some aspects that you're going to come back to. You're still developing policy on this and consulting on some areas around this. Didn't I read that?
No, not in terms of. Sorry, That's probably the reference in the report on consultation responses to the power to create a review mechanism. But there's been policy development and a confirmed approach taken in the intervening time between the report being published in 2021 and where we are now. So the actual draft amendment includes a provision to create an order-making power for the establishment of a review or appeal mechanism. It's at the very end of the text of the
Yeah, I'm just looking
amendment.
to see where I got this. Yeah, because my concern was, I didn't want this to end up being another, I don't know if you were here whenever we had the issue with the policing board where there was consultation around removing injury on duty away from the board. Well, it was consultation about injury on duty, and at no stage did the consultation include moving it away from the board, and the department said the board hadn't asked for it, which is astonishing. So I wanted to make sure this was why everything wasn't done in one go, but you're saying everything is. I can't actually find, I've written down the wrong reference, which is causing me consternation, because I can't find what I need, and if I do, I'll come back to it.
Okay.
But essentially then, everything is being done in one go. There's no further policy development. There's nothing, you're not reviewing anything else in terms of this.
No, I think where the confusion may come from, Chair, is that originally the changes to the table of rehabilitation periods and the ability to make more convictions capable of becoming spent were intended to be brought forward by way of secondary legislation.
Yeah.
And then there was a commitment to review to review an arrangement which had been introduced in Scotland, whereby an appeal mechanism, power had been taken to create an appeal mechanism. At the time when this was first considered in 2021, the power to create the appeal mechanism could only be brought forward by primary legislation. So there was intended to be a twin track approach. So
Find it, Andrew.
have you?
Find it. Paragraph 8
Of
of your report.
briefing paper that we
Yes.
offered? Okay.
Yeah. So it says the amendments also create an order-making power to allow the department to establish a review mechanism for some additional convictions not captured by the revised arrangements, following further policy development and consultation. The review mechanism is intended to mitigate against future legal challenges against the replacement of one bright line upper limit with another. So yeah, this is what I wanted to check. Okay, so what happens after the 10-year limit that's in this? What are you envisaging whenever you're looking at further policy development and consultation? What are the timelines and the next steps?
Right. Okay.
And do you intend to do that via statutory rule? And if so, what procedure?
Okay. Lots to try and
I
remember
knew you didn't
there.
make it up. I knew it. I was just finding a paragraph.
Okay. At the moment and going forward, any sentence over 10 years wouldn't be capable of becoming spent.
Right.
10 years is what we're proposing the new upper limit should be set at. That's obviously open to some discussion, both with yourselves, and I would imagine you'll have representations from some interested bodies that will be interested in suggesting different upper limits. We've set the limit at 10 years because that coincides with the definition of what constitutes a serious offence in another piece of legislation. And having spent a considerable amount of time in the High Court, the Court of Appeal and the Supreme Court in the last 68 years against defending the department against challenges against the rehabilitation legislation, the single most common point of argument is, why is the limit drawn where it is? And under the existing legislation, which dates back to 1978, there's no clear, coherent reason as to why 30 months was established as constituting a serious offence. Clearly doesn't constitute a serious offence in modern sentencing parlance. The changes that England and Wales and Scotland have made to change their limit to 4 years, 4 years in Scotland. Again, 4 years doesn't, there's no read across to any other definition of that being a serious offence in any other legislation. England and Wales have changed their approach again in that they will allow all sentences of over 4 years to become spent except for those that are specified as serious sexual, violent and terrorism offences. There's 170 something offences then listed. We took the approach of maintaining the core one of the core principles of the Rehabilitation of Offender scheme is simplicity and ease of use. It's a passive piece of legislation in that it establishes boundaries, it establishes limits that ordinary members of the public should be able to understand and read across to their conviction if they have a conviction. They shouldn't need expert help or an outside body or person to help them understand whether their conviction can become spent, and if so, when. So the approach that we've taken maintains simplicity of approach, ease of understanding. The read across is to the definition of a serious offence of being capable of having 10 years imprisonment set. So anything over 10 years not capable of becoming spent yet. The order making power that we're talking about for the review or the appeal mechanism would allow the department to consult on what a review or an appeal mechanism might look like for determinate fixed sentences of over 10 years. So no life sentences, no indeterminate sentences, no extended custodial sentences. And the reason for that is, as is the case with the judicial reviews that have been heard, where you have a bright line, it works for everybody that falls one side of it. For the people who fall just the other side of it, they're obviously going to feel aggrieved and they're going to take a case and say, okay, on what grounds am I being denied the same opportunity? With those just below 10 years, they're obviously, if these provisions are carried as they're drafted, they'll be able to have their convictions become spent. Those just over 10 years won't. So there is the reasonable expectation that they might seek to judicially challenge that decision. The review mechanism would then open up the opportunity for them to make application to the courts, because we would imagine it would have to be a courts-based system. If you're going past 10 years, it's very serious offending. That scheme doesn't exist in a format that is capable of being consulted on at this stage. It's still very much hasn't been implemented in Scotland, so beyond reviewing the information that they set in their regulations as being suitable for inclusion in an application, there's no means by which that's been tested. We think that it would be courts-based and would obviously require some kind of independent oversight decision-making. So that is an element that would be subject to further consideration and policy consultation.
So you don't envisage that becoming an issue in this bill?
No.
So
Only the power to create the order-making provision, which would then allow the policy development to progress, and then following that consultation and engagement with the committee, the review mechanism would be created by draft affirmative statutory rule.
You guys were working on this for a previous bill and it wasn't able to be included, isn't that right?
The provisions for change in rehabilitation periods and allowing up to 10 years to become spent, yes. The review mechanism, no.
No, okay.
This is entirely new. This is the first bill that there's actually been since the Scottish mechanism was created, and it was always going to be the case that it was going to need primary cover. Now, the assumption that I incorrectly made that the other changes could have been done by secondary proved to be my undoing once the Assembly come back, and now everything needs to be done by primary, including the changes to the rehabilitation periods for up to 4 years and 4 years to 10. And that's purely as a result of how narrowly written the order-making power to make changes by way of secondary legislation are drafted.
Do you envisage any risks in circumstances where the timeframes change but the review mechanism hasn't been looked at yet?
In the sense that the Scottish model still hasn't come on board, and the Supreme Court, at a hearing that I was at in October, were somewhat critical of the fact that the power had been available to the Scottish Government for, I think it's nigh on 4 years now, and there hadn't been any progress. Obviously, the longer that it takes for a scheme to be brought into being after the power becomes available, the more open to criticism the department stands.
So have you envisaged any time? What are the timelines that you envisage for this?
It'll be a question for my successor. Is the
All right,
very
Pontius
is
Pilate.
the very honest answer, but it is a. I did tell you last week that I offered the minister to throw myself at your mercy if a head needed to be put on the block.
We're not that bad.
No, you're most definitely not. It's a piece of work that I am attempting to progress at the same time as I'm managing this bill, at the same time as I'm involved in defending the department in the judicial review that the Human Rights Committee have taken against the existing Rehabilitation of Offenders law. So diminished resources, competing priorities, and
What sounds like a chicken and egg situation here?
as the bill progresses, obviously the focus will become more around the implementation of the changes that are going to be very quickly and easily able to be brought into operation. And in actual fact, the provisions of the provisions in the amendments that make the changes to the time that it takes for an offence to become rehabilitated, they'll come into operation automatically 2 months after royal assent. So there's a very fixed time frame there for those provisions to come into operation. That between the bill reaching final stage and going to royal assent, I'll be working on an awareness campaign to make sure that those changes in law are widely publicised, and then the focus will turn to the establishment of the review mechanism. And there's the provisions in the amendment set out. They give you a sort of skeleton of what a review mechanism might look like. You know, the types of information that we would expect a court would require in order for someone to make an informed decision about a person's unique circumstances. So it exists in theoretical grounds, but in terms of putting it on paper and getting it to you so that we can go out to public consultation on it, we're not there yet.
No, that's fine. I just kind of wanted to understand what the thinking was and why it wasn't all done as kind of one complete exercise, but that's fair enough. Thank you. Does anybody else have anything on rehabilitation? No? There you are, Aunt. You got off lightly today. It was just me.
My goodness.
Right. We'll move on to vagrancy. Who's up for vagrancy? Lorraine. We'll hand over to you then.
I have a wee bit of an introduction, so I'll just fire away. Thanks, Chair, for the opportunity to discuss the vagrancy repeal proposals today. The Minister has committed to repeal these provisions. She's fully aware that begging and rough sleeping are often linked to underlying issues such as homelessness, poverty, alcohol and drug addiction, poor mental health, sexual and domestic abuse and family breakdown. These are complex and cross-cutting issues which require a multi-agency response of support rather than criminalising people simply because of their personal circumstances. As Maurice highlighted in her summary, the amendment seeks to repeal the current vagrancy laws which criminalise rough sleeping and begging insofar as they relate to Northern Ireland. Specifically, Section 4 of the Vagrancy Act 1824 and Section 3 of the Vagrancy Ireland Act 1847. This follows a review of the law carried out by the Department following calls to repeal what is considered as old, outdated, archaic legislation. We don't propose to provide any replacement legislation upon repeal, but would instead rely on a range of other existing offences to deal with associated behaviours which reach the criminal threshold, such as harassment, disorderly behaviour and public order offences. Repeal of legislative provisions are not usually consulted on, as such a repeal is, in most cases, a consequential amendment resulting from the introduction of a new policy and primary legislation on which there would have been consultation. However, as we don't intend to introduce replacement legislation to replace vagrancy legislation, we considered it important to provide an opportunity for views to be submitted, particularly from key stakeholders, on its repeal. To date, we've received 7 responses to the consultation they received over recent days, and we've extended the time frame slightly to allow further time for another interested party or any others that might come forward who are keen to respond. We've also further promoted the consultation over recent days across social media to include a particular focus on the business and retail sector and those working within the voluntary and community sector. I'm happy to take any questions you might have.
Thank you, Lorraine. Lorraine, usually I go last.
Pardon?
Usually I go last in terms of questioning, but I'm not today because I've got a number of general questions and then I think other members are going to come in on the back of it, if that's all right. Now, I've got a considerable number here. But there's a reason why, and I'll explain. I don't think this is as straightforward as it may appear on the surface of things. I don't think any of us want to see people who are homeless criminalised, but I don't think the issue is that straightforward, and certainly not in Northern Ireland where we have trafficking and organised crime gangs and so on, and people can be coerced into begging, and not everybody who begs is homeless. So there's a few things that I want to pursue with you, if that's all right. Right. The consultation is closing on the 21st of January. So your consultation is closing after the amendment has been drafted. So what account will you take? I mean, what's the purpose of the consultation if it's already been drafted? What account are you going to take of what the responses are?
The Minister had, first of all, Chair, thank you. The extension of the consultation has been extended to 31st of January. I know that's only 10 days. The draft clause has been drafted there, but we have gone out to consultation and we fully intend to take any responses into consideration as consultation. The Minister had committed to repeal the provision because it is old and archaic, and the review had looked at the application of the vagrancy legislation in Northern Ireland and as compared to other jurisdictions, and we consulted very closely with police on that. So while the clause is there, Chair, we're fully intending to consider the consultation responses and any particular points that are raised from that. Currently, it's a Minister's view following her review that there isn't a requirement for replacement legislation on the basis that police, we had consulted with police, and the only gap that they have highlighted to us is simple begging, that there are other pieces of legislation within the framework to deal with criminal behaviour around those particular, the rough sleeping and begging. So the short answer is we will be considering the consultation responses.
So if the consultation responses indicate that there's a gap from the repealing of this legislation, then what?
If there is a significant gap, I mean, that would have to be analysed and considered by the Minister. If there's a significant gap, then what we would seek to do is bring work forward within the antisocial behaviour. Its colleagues are deemed the antisocial behaviour strategy and strategic work around that. More have you anything to add to that?
I was just going to add, you mentioned there the likes of human trafficking, organised crime. I know that Lorraine and her colleagues did explore specifically with the police whether they anticipated any issues in those sorts of areas. And you might recall I did sort of flag in September that we were a bit out of sequence here in that we were proceeding with drafting the amendment before we'd consulted, but it was really because we'd wanted to take the time we needed to take with the police to explore these sorts of issues very thoroughly with them, which took longer than we'd anticipated. But they were satisfied that really the only gap that they could see was what they refer to as simple begging. So that takes us back to the principle of, is that something that we want to criminalise? Is someone who's, sitting with their hand out asking you for change as you go by, but not otherwise being a nuisance, is that reaching a threshold for criminal behaviour? This feels more to us to be in the antisocial behaviour space, as Lorraine's talking about. But we want to give people the opportunity to flag any sort of practical issues, problems they foresee could arise. But to be honest, the solution to those may go beyond specifically what we do with regard to the criminal law. I think we are looking more at wider societal response to the problems of homelessness and poverty. And we're looking at joined up multi-agency working, and that is something the police had flagged with us as well. The fact that, in a way, because we have the offences available, it almost invites people to look to the police in the first instance and for them to be the first point of contact when an issue arises. And you've been briefed before on, sorry, what is it, right?
Just right person, right care.
Right person, right initiative.
Yeah, so I always get it the wrong way around. Should it be the job of the police to respond in the first instance where these issues occur? Could we be looking more widely at a broader response to that? So, ideally it would have been better had we consulted sooner, and we appreciate that. But I think the consultation, what we're specifically looking at is there a gap in terms of the criminal law given the offences we already have?
Yes, because there is, as Maurice says, in terms of the organised crime element, we did raise this specifically with police. So our review did look at the application of the vagrancy legislation, the types of protocols that police had established with support organisations, the existing law around that, and how they approach those issues. What are the types of issues that they're coming across? Because the police are the first point of call. They are the first responders to these types of cases. So they would engage with that person, whether it's rough sleeping or begging. With rough sleeping, they don't arrest people for rough sleeping. For begging, they would explain to them that this is an offence as it is currently and encourage them to move on. And they always then would signpost on to support services around that. And police have formed partnerships with a number, depending on the particular police area, with a number of support organisations. So that came across very strongly in the review. This is, as Maurice says, a multi-societal issue, and it's multi-agency. And criminal justice is one element. Dealing with someone is one element with the police. There's a good body of evidence to suggest there's a lot of work, really positive work that's been taken forward. For example, Belfast City Council with the Complex Lives initiative. It's a really, really good initiative. They work with police and businesses around trying to, embrace the person into their actual needs, wrap around that, encourage them to create a more stable environment for them, and that's a very worthwhile initiative. But police also have partnerships in their own districts with other bodies, so it depends very much. The services will be tailored to the issues that actually present themselves in the various areas. So begging would be very prominent in Belfast city centre. They would be prominent in Derry, but not as much Derry, Londonderry, and also Newry, but they're very much lesser sort of areas in terms of begging, and it would be around, you know, the hotspots of the ATM. I think we've all seen those people. Now, police have not, as Maura said, police haven't identified, other than, you know, simple begging, which the Minister doesn't support because it does criminalise someone in relation to the sort of circumstances in which they find themselves in, personal circumstances. They're not harassing anyone. If they're harassing someone, there is legislation to deal with that, and so forth. So that's where we're coming from. We've looked at it very critically, but in saying that, Chair, the consultation responses may pull up some other points that we need to consider. But simple begging, as the police perceive this particular gap, it's not something that the Minister would support in going forward.
Consultation response to some of the issues they may raise, maybe in the more general space of antisocial behaviour, we suspect, and how you address that.
Yeah, because, you know, the evidence has come back. There was a piece of research done, for example, in Dublin, City Centre commissioned by the council there, and in south of Ireland they've a slightly different approach. They had actually repealed or struck down, it was actually a court ruling, High Court ruling, which struck down the Section 3 of the Vagrancy Act that we're actually seeking to repeal on the basis it was unconstitutional, and that was around freedom of expression. So that was in 2007, I believe, and new legislation was introduced in 2011, and that was just to introduce aggressive begging and organised begging. Now, the piece of research that was done suggests that was 2016, that there was an increase in begging in Dublin, that there was a need for multi-agency approach, that it wasn't just down to criminalising someone, and it's better to deal with the underlying issues rather than, you know, the symptoms. So that's very much the approach that's been taken. There was really good evidence of that demonstrated in our review.
I'm glad to hear you say that, because that was one of my concerns, that it's okay to not criminalise, but what are we actually doing to help people?
Yeah.
You know, because if you're saying to them, no, it's not a crime, but they're still just left. And I mean, and you flagged the issue there, Lorraine, about organised begging, but that remains a worry for me, because I think that there are people who are forced to beg.
Yes, and
right across
exploitation.
the UK and Ireland. I think people are forced.
Yes, Chair, and in that sort of sphere, we do have strategic, drivers to change that. We have the organised crime, we have our legislation around trafficking, so there are other ways of dealing with that issue. What we're saying in terms of this repeal is that it is about, repealing the legislation on Section 3 and Section 4, and not replacing it, because simple begging is the only perceived gap that the police see in the legislative framework, and that's not something which we support. That's somewhere, as Maura says, someone sitting, and we may be uncomfortable, I think, about seeing those people, but if they're not obstructing, if they're not being aggressive, they're not harassing or being disorderly, it's something that we need to look at.
Yeah, but I do think that sometimes the police coming to those people who have been trafficked or who are forced to beg affords them an opportunity to ask for help. Mm-hmm. And if they're not being approached and they're not being moved on, or nobody's speaking to them at all, and there's, well,
the police will always, this won't change this, Chair. I mean, it won't change. Police will always still respond to an incident. If they get a call about someone begging or rough sleeping, they will call to that part. They will deal with the incident. That's day-to-day policing. It's just that they won't have that power to, if someone's not, getting involved in sort of harassment or creating that sort of criminal sort of behaviour.
They said they'll continue to do that.
Yes, they would. Well, they haven't said that, but that would be the outworking of that. I mean,
I'm just not sure. I mean, given the resourcing problems that they have, I think if something's not a crime, I'm not sure that the police are going to turn up. I mean, that's something that we can pursue with the police. But I mean, I kind of want to move on. I'm conscious of time, and there's other people to come in. So a couple of things then. I'm keen to understand what conversations you've had with local councils here, and what powers it leaves with local councils, because as you say, as I feel, there are two different sides to this. There's the person who is homeless and has a chaotic lifestyle, who shouldn't necessarily be criminalised for that unless they're engaging in criminal behaviour.
Yes.
However, there are impacts. There are impacts on tourism. There are impacts on the shop owner and whose door they're sleeping in. There are impacts for councils. So, what engagement have you had with local councils? I'm conscious that certainly in Glasgow, before this legislation was passed, in Scotland, Glasgow Council had some serious concerns over it and the outworkings. And there are considerable numbers of homeless people, not all of whom beg, but some who do, and some others who just beg in Glasgow. And I mean, that can have a chill factor for tourism. So what conversations have there been around
We
all
have,
this?
with the review, we spoke principally to the Belfast City Council because that was the sort of the bigger cohort of individuals that we were this policy was engaging. So we spoke to them. That was a very positive conversation, and they flagged up the Complex Lives initiative, for example, and we talked at length with those. We have, as I say, received 7 responses. So some of those have come from business owners, for example, and a council as well. So we have had 1 council response so far, but as I say, that consultation hasn't ended yet. I'm conscious of the Scottish experience. Begging isn't novel to any of us. It's not novel to this jurisdiction, to your neighbouring jurisdictions or wider in the world. I mean, they all deal with it in different ways. And Scotland, we would be aligning our proposals very much with Scotland. Scotland doesn't criminalise begging, simple begging. They deal with, and they have repealed the legislation that we're repealing in the UK piece and the Section 4. They repealed that in 1982. And they haven't, there are always going to be certain issues around this particular area, but that has been repealed, and they have worked off their existing body of offences to deal with any of the behaviours that are associated with begging and rough sleeping. Glasgow was one of the areas in Aberdeen that actually applied to the Scottish Government for permissions of the Minister to introduce bylaws to begging, and that was refused by the Scottish Government, not on one occasion but a couple of occasions. They've been very consistent in their messaging that simple begging in itself should not be criminalised, and that dealing with the associated behaviours around that sort of delve into the criminal space are those they're sufficiently there. So they have it's a very similar approach that we're adopting. England and Wales are different. They're still using Section 4 of the Vagrancy Act. That's the UK-wide Act for rough sleeping and begging. They had included a particular repeal provision in 2022 legislation, the Policing Courts Sentencing and Crime, Policing Crime Sentencing and Courts Act 2022, and they have a repeal mechanism there, but that has not commenced. They intend to include a replacement provision. That replacement provision was included in the Crime and Policing Bill of the last UK government, and that bill unfortunately fell. Well, I don't say unfortunately, but it had fallen. That had included particular provisions for civil prevention orders to deal with rough sleeping and begging. And those would be civil orders, but breach of those orders would have been a criminal offence of up to 1 month imprisonment or fine. So that bill had fallen. There was a lot of criticism around there was offences of nuisance, rough sleeping and nuisance begging in it, and that had drawn criticism from the Conservative, some Conservative MPs who actually tabled amendments to have it done away with. They didn't support it, and some Labour MPs, but as I say, that bill had fallen. And we have checked with colleagues about any resurrection or interest to progress that by the new government, and there's no decision made on that at the moment. As well as Section 4, the England and Wales local authorities, they rely on these public space protection orders. But when we looked at that, a critical analysis found that there was about 125 of these people, these particular local authorities were actually using them to target homelessness. So they were very critical of how they're actually used in England and Wales. So you can see there's quite a mixed sort of approach. In Europe, it's a very mixed approach as well, but there's some sanctions for begging, there's aggressive begging. We know that in America, for example, it's contrary to the First Amendment under freedom of expression. There have been some human rights sort of case law around it. In Switzerland, there had been a successful case of a lady who was begging, and she was challenging it under Article 8, right to family private life, and found in her favour that it had breached that. She had been given a fine and wasn't able to pay the fine, and she was in prison for the 5 days. So that was Switzerland approach. There was also a case in Denmark. I should say the Switzerland approach was an outright ban on begging. So the lady didn't have any other means in which to, to gain any money. She had no benefits or employment. By comparison, Denmark, there's a particular individual there had applied but was refused judicial review, and his particular plight was around Article 8 and 10, but that was discounted. It wasn't, while there had been a ban in Switzerland, it was an outright ban, so there had been issues there. And as I say, the human rights element of the Republic of Ireland approach, where the High Court had considered it unconstitutional, so there are sort of case law elements around that as well.
Okay, that's fair enough. I remain concerned around some of this. I don't think it's as straightforward as being made out. I'll be interested to see. It seems to me that no matter what the consultation is going to return, then the decision is made and we're progressing anyway. But I would like you, if possible, if you don't hear from them in the consultation, I think it's imperative that you would engage with the Belfast Chamber of Commerce. I think Londonderry has one too. And the Northern Ireland Chamber of Commerce, not just from the economic perspective, but actually, I was at an event on Monday where it was raised that a person who had arrived at their firm, member staff to open the premises, and somebody was unconscious in their doorway, and those people had to proceed to resuscitate that person. And wait until the ambulance came and the police came. And actually, that's a very traumatic circumstance for a member of the public to have to deal with, and we know that people develop kind of regular spots that they would go to sleep in. So people, if you're going to do this, people need to be ready, and you need to understand that has an impact and it takes a toll on people when they're having to deal with everything that ensues when people are unwell. Yeah.
And I think the police, their view for rough sleeping is that should never be criminalised, and begging, yes, there will be instances, I suppose, when you'll have instances like that, but there are bodies, there are support mechanisms around that, and it is about nurturing that and building upon that, as opposed to actually criminalising someone who has very complex needs.
But I think it's about the balance, and
yeah.
I think that the people who pay very high rates across Northern Ireland also need to have their views taken into account. We're not heartless. I don't want to see people criminalised when they're having a tough time. But I think that there are people who exploit it, and these people are also trying to, they're trying to earn their living, and so I think we just need to be careful and make sure we hear from all sides. Is my argument on that. Anybody, Deirdre, you wanted to come in on this, and then
I
Doug?
think broadly we'd be supportive of repealing the vagrancy. And I suppose one of the questions we had asked previously was just in terms of what other jurisdictions were doing, and we know in the south, for example, because we would have a concern around organised activities and even people being forced to beg as well, and just around having kind of zones around bank links and things like that, which we know they've moved on in the south. So it's just to see what assessment has been done around any potential gaps. I suppose that's the concern, is around are there gaps, and are you confident that there's existing legislation that is there? Have you done an assessment on that in terms of looking at this at the moment, just to make sure that, I know you've said we'll look at it under ASB, but that might take some time, and what happens in between. So it's just to try and get a sense of gaps, and is there anybody beyond the PSNI? I mean, obviously they would be first responders in a lot of cases, but particularly, you know, Joanne's touched on the business community, you know, but the homeless community, those within the community and voluntary sector that probably are on the street dealing with these issues and see it at the cold face, if you're picking anything up from them as well.
Yeah, and the police had been very clear that simple begging was the only gap, that outside of, you know, overt nuisance, organised and aggressive begging. So that was the gap in law. In terms of, you know, the wider support services, there has been good evidence there that there is a strong willingness to come together as partnerships and do this together. And it was something that was drawn out of the Dublin experience whenever that piece of research was done there, that begging is increasing, even though they have brought in aggressive and organised begging. That is increasing, but there is this whole drive to make sure that we have that body of support around those people, and it's multi-agency, that it's not just justice, it's not just about criminalising the person, it is about those wider issues. And we're talking about a smaller cohort of people here. I know that the House Executive, they keep a very watchful eye on numbers, and I think there was a spot check done in November of 23, and there were 45 individuals in that sort of entrenched type of situation. And these people have very complex needs. I know when we've spoken to some stakeholders, they've said that, you know, they can help the individual and give them accommodation and so forth, but their needs are greater than that, because they sometimes then miss the life on the street. So there are very complex and underlying issues around this with drug and alcohol addiction. And I mean, any of us can be, and I think that came out of the Complex Lives initiative, anyone can find themselves in this situation. It's not just about addiction, it could be a breakdown of family, you know, say mental health, there's all sorts of types of reasons why, but it is a very small cohort. We're talking about rough sleeping, begging, you know, there's the three sort of main areas where it's very, you know, it's more prominent, I should say. That would be, you know, Belfast, Derry, Londonderry and Newry, but there's also Armagh, Banbridge and Craigavon have sort of like recurring cases of it, but the police they're very involved in partnership working and across the voluntary and community sector, as well as the councils and the businesses. So they're all working together, you know, to try and address and respond to the issues that are presenting themselves, and that all is individual to the police area, really, Chair. Thank you.
Doug?
Yeah, I mean, I think you covered that really well, actually, and some of the answers I think were very good. Look, I'm broadly again supportive of getting rid of the vagrancy laws. Nobody should be criminalised for being on the streets, but I do still have those concerns, as the chair has articulated, and that is organised begging. We have certainly had people who get the train into Portadown to do begging, and then get the train back in the evening to wherever they live, and that's in the Armagh, Banbridge and Craigavon Borough Council. And that real concern as well is that the police will not do welfare calls to people who are on the streets, because there's no criminal charge to go and check up on. I mean, it remains a concern. It is very nuanced. And look, and I think we'll delve into it. I think your answers are pretty good. You know, but I think, like the chair says, I think it's not as clear cut as just repealing the vagrancy laws.
Thanks, Doug. Stephen?
Thank you, Chair. Just thanks for your details so far. Just to echo some of those comments, I suppose, just to emphasise from my experience as a local rep, you know, that some of these people are being exploited, you know, and I think that can't be lost in it, as Doug has mentioned. Unfortunately, not by choice in many cases. I know that from my own constituency, a few miles from here. where people are coming, from other areas of Belfast and so on to beg. And I think, I'm not sure whether removing tools, as is the case here, is the best way of dealing, ultimately with that issue. Just on that then, is there the evidence, concrete enough evidence, that the Scotland model, is the best approach to ultimately, we all want to see people not having to beg in rough sleep. Are you confident within the department that the Scotland model, as you touched upon, is the number one model that you should be looking at?
Well, it's certainly it's a successful model from what we're learning from our counterparts in that, and also PSNI had been engaging with their counterparts as well as part of the review. So, as I say, that was repealed. That legislation was repealed in 1982, and they haven't included any replacement legislation. There is a body of law similar to our own law which deals with surrounding issues. So we would be confident is a safe enough model. I think is the answer to that.
I suppose, just in my opinion, the more tools you have at your disposal, the better. If and when required, hopefully they won't need to be used at any point. But many of these people's Chair, as you know, are victims, as you said, of human trafficking and so on. And there is a point, and it is a fact out there, that some people can feel uncomfortable, with folks that unfortunately have had to resort to begging and so on. We think of, lone workers and female workers and so on, and different things that may be closing very late at night or early in the morning. So, there is issues like that. And the business sector, then, I presume they're just within the consultation. Has there been any other feedback from them?
Yes, well, we have received, we've received responses from the business sector, and some of those are umbrella groups representing quite a large amount. I think one represents 600 businesses, for example. So we're getting good feedback from there. As I say, it's too early to draw any particular analysis of that because we only have received in recent days. We hadn't any responses up until the past couple of days. And we pushed out then in social media, our press office, to try and encourage people to respond. So, as I say, they've been flurrying in, and we got another one in there this morning. So, but yes, we've got responses from the business sector, which we'll take full consideration of.
And obviously, once we've had a chance to analyse those responses, we'll come back and update the committee and brief you on that.
But the organised crime and exploitation, that is a wider issue, and we do have the organised crime task force. We do have trafficking and exploitation law, so there's work being done in those areas as well.
Yeah, and I do feel when that opportunity, when the police can get involved, when the police can get involved, that can be a rescue and a lifeboat to somebody.
But if they're not going to come out to a call when there's no crime being committed, then you're diminishing the opportunities there.
I do believe so,
I think, but anyway.
But I think the police would say that there are other organisations that maybe should be that first point
maybe, but
to contact.
how do you prove that they're trafficked? How do you who's like? I just think it's not straightforward. It's not as straightforward as it's being presented here. There's no question.
The police will engage, Chair, and that will be part of the normal day-to-day policing. They will engage and that engage and explain. I can't see that being hugely different from what's being done. They'll go out to an incident and they'll make an assessment on what the needs of that person are, and they'll have, I'm sure they have intelligence as well if there's a particular group of people that are in this organised sort of sphere as well. So they will get as much as they can from information from that person. So I can't see them.
Just one final point. The criminal gangs that unfortunately are at the the end of some of these chains. Would it be the case that they would be in favour of this move towards decriminalising?
Criminal gangs?
Yeah, that are sometimes sending people, to beg for them.
You think it could be advantageous to them? Is that what you're
saying?
Well,
that's the question I'm asking. I feel, could it be? And if it was, something, that's why I would have concerns about.
Well, the police have told us that the only perceived gap is simple begging. They haven't raised any issue of organised begging around, that there's any particular issues there. So I think the answer to that is we just don't believe that there is any other gap. The police are telling us that simple begging is the only gap, and there are other ways of dealing with these individuals.
These folks are, they are victims often, and I think we
Yeah,
need
I
to have
appreciate
all avenues
that.
open to protect them ultimately.
Yeah, I appreciate that.
Connie?
Yeah,
Thanks,
thank
Chair.
you, Chair. Thank you. It's been really comprehensive explanation of the amendments you're bringing forward, but I think it is really important, and it'd be no surprise that obviously I support them, and I think it is something that does need repealed, especially in the context where these laws just aren't used to criminalise people. And I think I wanted to ask, because I'm very conscious of the things people have raised about organised crime, and if there's any way, if it's within your remit, could you speak to a bit more of the work the department is doing on that, because I know the human trafficking legislation was brought forward in the last mandate, and there is a lot of ongoing work to tackle organised crime, and I do think that homelessness and begging and the crimes that are in these vagrancy amendments, I think it is a social problem. It's not a problem, for the Department of Justice. So if you could talk a bit more about how we can tackle organised crime, as people have raised concerns about, I think that could be quite helpful.
Well, if you're amenable, could we write about, it's another area of the department that deals with that, and if you're happy, we can explore it a bit further and come back.
If the committee's agreed.
Yeah, is that
I
helpful?
mean, look, as much information as we can get,
Okay.
then all the better. But
And as Lorraine says, we have specifically asked the police about this, but we're happy to sort of check in with them again just to see
Yes,
if they have any
concerns.
concerns.
It's
in
something
that
we
area.
did press with the police, and it wasn't something that any particular,
No,
that
but
didn't
I
raise
suppose-
anything.
I think what we need to press with the police is, if this happens, I mean, Lorraine, you refer to them going out to an incident,
Yeah.
but at this point they'll say there's no incident, so there's no need for them to go. We already know the pressures that they're under, so I would want to, whenever we take evidence from the police, I'll be wanting to check with them, right, are you actually going to go to these calls? Are you going to do anything about this? Or are you going to say there's no crime, there's no reason for me to go, there's no threat to life, there's no, people are not threatening to harm themselves or anybody else, so we're not going? And where does that leave everybody? And the other thing that I want to check with you finally before you leave is, you've referred to cases in Dublin and so on of organised and aggressive begging that kind of, there was an uptick in these once the vagrancy laws and begging laws were repealed. So what scope, what preparation has been made were that to happen in Belfast? Because, I mean, you referenced, Scotland as the model to follow, and Scotland has been very successful. I don't know when the last time you walked around Glasgow was, but I was there recently, and it's very difficult. And do you know what? It's just very difficult to see. Actually, I'm not saying that from any, judgment perspective. I'm saying it from, it's hard to watch, it's hard to see, and actually there's people who are incredibly vulnerable, and people who are absolutely there to make money. And if you're able to get the train from one place to another, that indicates that begging can be profitable. That's not to suggest that everybody who engages in it isn't needy.
Yeah.
But clearly there's another side to this, a seedier side.
Just to highlight too, when I said about the successful model, I'm talking about the repeal of the legislation. I'm solely talking about, issues, wider societal issues on.
No, I understand that, Lorraine, but
Yeah.
my concern is, I think we can all look at the moral aspect and say, yes, ideally people who are in that situation would not be criminalised. You should not be criminalised for being homeless. However, it's not that straightforward, and I think if it becomes clear that the police don't turn up, there's an uptick in aggressive begging, in organised begging, then what powers do the police actually have to deal with the situation? It's the outworkings that are of concern. Not necessarily just for the homeless person, but actually for the people who are exploited, for the people who for where this has the potential to go wrong. In an ideal world, of course people wouldn't be criminalised, of course they wouldn't. But I don't believe for a second that at the point at which this is no longer criminalised, that there won't be criminals who will seek to exploit it. And moreover, I don't believe that the help will be available to those people who need it on time. And then the statutory agencies aren't going to come because there's no crime. So that's what I'm worried about. If we're going to do this, get our ducks in a row to make sure people are getting the help that they need. That's my view, and that's not all in the DOJ, by the way. I get it.
Appreciate that, Chair. Thank
So
you.
those are just some of the things that are kind of occurring to me, because this is all being presented like it's very straightforward, but actually when you're walking through some of these cities where it's happened, there are safety issues and so on too, even for the people who are on the street. Right, Ciara.
Just to make a quick comment, and obviously I understand the concerns, Joanne, that you have raised, and it is more complex. I would just like maybe to recommend, and looking at that bigger picture, and I know there's some concerns about the police won't call out and stuff, but there's some really good models of practice, particularly in Derry, and I have worked as part of a wider team with the Housing Executive, with the PSNI, with supporting people, organisations, a plethora, with local businesses who had concerns through working groups, and they've set up expert working groups then within council, etc., and they continue to work through a process of enabling and supporting the person who's most vulnerable. The organised crime obviously would be separate to that, but there is good models of practice that maybe it's something you could look at, and looking at the wider picture or the implications or repercussions of this and the concerns. There is good working models.
And we did look at those models very much as part of the review. So we were aware of there was good evidence of good practice across all of Northern Ireland. It wasn't remote to Belfast City Council. There are in partnership working with the police. I think they're all trying to adopt a multi-agency because it isn't just about justice, it is that that sort of wider societal issue. So there are good, and we have looked at that as part of the review as well. But thank you for those.
But it is difficult. I can it's balancing that it is difficult, but it's about the building the relationships and the trust and working together, and you can overcome any.
Yeah, and that's where the anti-social behaviour. I wasn't sort of trying to push that across to our team there, but they have a strategy, and they're developing. I've just consulted on a strategy about other elements, about looking at antisocial behaviour law, about drinking in public places, which a lot of this involves, with begging and rough sleeping. So it's sort of that joined up sort of working.
I understand. Like I'm to be honest, I'm humane. I'm not taking any pleasure in raising the other side of it. But I think we'll have to consider the other side of it because there are unintended consequences. So, Lorraine, could I ask then, when you're coming back around the organised crime aspect, could you also come back to me on around, okay, well, what powers and options are available to the council, to the police, to businesses? Should there be an increase in aggressive and organised begging as a result of the repeal? Would that be all right? Are members content that the department will come back on that one? Yeah, thank you. Did you want back in, or
I was just sorry you touched on in terms of the last crime and policing bill in Westminster that fell, obviously, but it's being resurrected again, and the potential of an LCM. So I was going to ask it in the correspondence bit around, but pertaining to this specific issue of our vagrancy, are you aware of anything coming through?
At the moment, we did check as early as yesterday evening with our colleagues in England and Wales, and there's no plan, there's no decisions taken by ministers as yet.
Thank you.
Okay. Have we moved to live links? Mara, that's you, is it?
That's me,
right,
yes.
Over to you.
For the purpose of the Hansard record, I note that I was described as the head of legacy, policy lead and legacy of that. I'm not. I'm senior legal advisor, and I'm policy lead on live links and a number of sentencing areas that would be included in the sentencing bill when it comes forward.
That's helpful. We'll get that corrected. Thank you.
So it may help if I kind of just give a quick scope. Maybe a bit like what's new, what's not, in the clauses, if that helps. But in the context, I would wish to emphasise, clauses don't set out detailed proposals of how courts should be run. They are enabling in nature and really have been provide a general framework for the operation of electronic court or tribunal business, rather than being prescriptive. The policy aim was to retain the measures in the 2020 Act, which can deliver significant longer-term benefits, but also provide a basis for access to justice, fairness, and improving transparency. Much will be familiar in the clauses to those who've read or used Schedule 27 live link provisions, but it's not a replication. They build upon user experience, responses to the public consultation, various engagement exercises conducted by the department, as well as developments in neighbouring jurisdictions post-consultation. The intent is that the measures will enable flexibility, appropriate choice, and a person-centred approach in the way processes are managed for those who use the system, including victims, witnesses, the accused, and maximise the use of technology where appropriate in our procedures and practices. It's hoped that most will agree that the clauses do align with the proposed future model that was included in the Way Forward report, published in September 24. What is new, if we move to that, is we're creating a framework for all courts, criminal and civil, while the pre-2020, it was only primary legislation that had criminal, and the civil was mostly in court routes. We're also creating a universal test, while from 2011, 2015, the description could be that there was multiple formulations and different tests. In summary, we are also introducing a type of third live link direction called a limited transmission direction. That's clause J905. We're introducing a statutory obligation for the judiciary to have regard to the Lady Chief Justice guidance. That's J902. We're refining what a person attending remotely has to see and hear to reflect the potential impact of other special measures which might be made by a court. We're refining the offences that were created through the 2020 Act to accommodate remote participation, as well as the broadcast provisions that were introduced into the 1978 Act, and accommodate the potential of selfies. And we are including a power to apply to vary the directions which previously the legislation only allowed grant or rescind. What's not new? Many of the conditions to be satisfied for the technology to be a live link, who will be defined as a participant and able to apply or have their view considered, and in what circumstances before a live link direction is made, the requirement to give reasons when an application for a direction is refused. The provisions within J901A simply reflect provisions that were already in relevant criminal legislation but have been adjusted to reflect what's appropriate to reflect civil jurisdiction and the need for a court to provide reasons. We've been very conscious striking the right balance between in-person hearings and electronic hearings. Hearings will never be an exact science for the judiciary, but it's hoped that the requirement to have regard to the Lady Chief Justice guidance alongside the provision of reasons will deliver increased predictability for court users so that they have a more informed view on how and why a decision or mode might be taken and deliver improved consistency across the courts. The provision of reasons is linked to the principle of open justice, and a number of the clauses that have been introduced have been with the purpose of enhancing open justice. And we don't expect that decisions on remote observation will require detailed rulings. The clear expectation is that a couple of sentences setting out a judge's reasons will suffice, particularly if they reflect upon the range of guidance issued since the Police Crime Sentencing and Courts Act 1922, when live link provisions came into force. I'm happy for any questions.
Thank you, Ciara.
Thank you, Mary. Just specifically, has the department engaged with the Human Rights Commission?
We have not only had the benefit of their response to our public consultation, but we have engaged with them since that. Yeah. And I can say that we have been very conscious of ECHR and its compliance and our international obligations. And I think, in fact, the public consultation, if anybody had read it, from Chapter 1, which deals totally with trying to explain what rights are engaged by the policy, we very much have flagged up Articles 5, 6, 8 and 10. They would be the primary ones. And the NIHRC didn't express any serious issues about it, merely flagged, in fact, mostly research, maybe if it had been conducted. But when we engaged with them, they had no actual examples of it having been an issue. Anybody raising saying that they either were compelled to do it and it wasn't appropriate for them, or it wasn't in the interest of justice and that. And throughout this process, in particular regarding the statutory rules that have been extending live links, again, I'm the policy lead in relation to that, we have constantly engage and update as to what's happening. And I would emphasise that very much every member of the judiciary will be aware of the Equal Treatment Bench Book. The Equal Treatment Bench Book addresses very much about adjustments, ground rules, hearings to be conducted to ensure that you have effective participation. To do that, they even have in the most recent revised version, which was July 24, and it's available on the World Wide Web. Any member of the public can access it as well. There's a new appendix which they've put in about remote hearings.
Well, that's really, really useful, really, because one of both the main concern for me is particularly around children and young people, and particularly, I suppose, that there is a benchmark in relation to that the child does understand, particularly our most vulnerable children, and I've had experience of that, where particularly when you have a young person who is under the care of a parent and maybe is arrested, is charged, have serious issues regarding level of understanding, level of knowledge, etc., where the mum is probably the one who knows the best in relation to what her son may or may not understand, etc., etc. So it's just that area of work. I don't know if is it in this adjustments
right, so the
model. It's just around vulnerable young people. That's where I would
the
concerned
Equal
that their
Treatment
consent.
Bench Book is a huge document.
Yeah.
Okay, but it has separate chapters about disability needs. It has separate chapters about the young people. But it covers race. It covers all the things that you would want the person who's sitting there hearing your case to be able to make adjustments for the purposes of that hearing that needed. Now, in terms of children, obviously we have special measures which sits outside and apart from these wider use of live link provisions.
Yep.
And these will in no way cut across them, but in fact you will see in one of the clauses we have adjusted in J9303 to ensure that any order that is made by a court in another way that could impact. So I'm thinking of like a screen or something like that. That for that purpose, the basic definition, which is that the person attending remotely should be able to see and hear the members, and they be seen and heard, but it won't apply. It'll be adjusted for that, but just like it's adjusted for those who have a disability like blindness or can't hear. So that this is more refined and improved, I think, in terms of to reflect the lessons we learned, because the legislation, when it was created in a rush and very quickly, and that bit was missed, if you know what I mean. But it makes a difference to have it clear. People practically expect, adjusted in the courts to do so, but it's better that it's clarity in the face of the law.
As you mentioned, it was page 82, I think, of the report, the special measures, and they can vary.
Special measures can vary. The live link is only one of the special measures that are available to the court. You can have intermediary, you could have interpreter, you could have a screen, you could have the screen that's operating to hide the witness, or you could have the screen operating so that they don't have to see the public or the defendant. So it's capable of being adjusted. And in the Equal Treatment Bench Book would say that there might not even be in legislation some of the adjustments, if that's what's required to enable a person to have effective participation.
And what is the benefits for children and young people in
Well, there's
live links?
right across in Scotland, even more. It was to see from their consultation, which is more recent than ours. Ours was 22, theirs was in 23. Going into 24, but the same experience, in particular for children and in their parents who may also be a witness in a case, being able to have had this wider provision of and be allowed to use the remote evidence centres, where they can have what I would call child-friendly environment. They are kept together. There's absolutely no prospect of them coming across the defendant's family or anything. They're in a separate building, well away from the court. And they all find it less traumatising. The Guardian ad litem has given very positive feedback about the experience for in family case law where they've been engaged and with young children. So I think there's no doubt that the use of video link, as it has with special measures for children, has enabled them to give their best evidence, or at least increase that chance.
And is there, just finally, sorry, through the chair, has there been any evidence or any suggestion that in certain circumstances it shouldn't be used?
Not in the case of children. I don't believe there's been any research. The difference has been about family courts, which obviously engage the children, but children are rarely the witnesses or parties in that. But the family, shall we say, the adults engaged in it, some of them would have found it inappropriate for their use because it's an emotional setting. It's difficult, and that, shall we say, distance between perhaps the person asking the questions and difficult questions, and then maybe not being able to control your emotions in a way that maybe in the physical courtroom you'd have been more aware you had to cause some issues in the earlier times. I think the Lady Chief Guidance, Justice Guidance gives a really good picture of those cases that have, through experience, that have indicated might be more appropriate for in-person hearings and those that might be more appropriate for remote. And I think you'll see family, in particular, the final disposal of a family case would be very much viewed as being more appropriate for in-person hearings.
Thank you.
Okay, Ciara. Justin?
Thanks, Chair. Thanks, Maura. Listen, thank you for your evidence, Maura. I think you're quite clearly very passionate, very informed, and very invested in this issue. Does this fundamentally improve justice and access to justice for children and for those groups who may need to access live links? Does it make the justice system more approachable for them and more meaningful for them, where they're able to access justice more readily, given the more comfortable position that they may be able to achieve through this facility?
I think the first thing is that there's no one fit for everybody, so I don't want to be seen to be answering as if everybody's the same generic approach. But in terms of the responses that we have received from our consultation and also to engagements that we've conducted and continue to do so, but equally I think when you give an additional tool to the courts or tribunals, and I think we mustn't forget about tribunals, because children quite often are there with special educational needs cases, the children's appeals against who put them in what school, and that. So an extra tool will never be a disadvantage. A tool that allows you maybe to be in a less formal setting and with somebody beside you in terms of for children that's not, shall we say, interfering with what's happening, but just quietly supportive there, I think has to help. Because I know lawyers who, if they ask to be called a witness, don't want to give evidence and be on a sworn witness in court. They wouldn't just walk in and say, no problem. So I think we can't underestimate that nobody engages with the courts quite often willingly. Quite often they're the reluctant good citizen that's been caught up in an incident, or they're the victim of a crime. And I think anything that makes it more individual and centred for the victim of crime is a positive.
Yeah, okay. Yeah, well done, Maura. Thank you very much for your evidence. Appreciate the answer.
Thanks, Justin. Maura, I just have a couple of things. On your briefing paper, the penultimate page of that, the first kind of full bullet point that there is there, it says, where determination is to refuse the use of live links to state its reasons for concluding the use of live links was not in the interests of justice. Could I just clarify in terms of that one then? So is there a presumption in favour of live links as opposed to live links being an option or an exception?
No, there isn't a presumption. However, In saying that, we are proposing in one clause a very, very limited statutory assumption. I think it's J901A, no, J902A. But that's a thing. There's no presumption. The test is very clear. The test is the use of live links, either for this individual or this hearing or this preliminary proceeding in the interest of justice. And the arbiter of that is the judge. That does not change. In terms of for the giving of reasons, that's linked to, and the way it's phrased, that's linked to the fact that they're required now, if the clauses become law, that they will have regard to the Lady Chief Justice guidance. Some of that current guidance gives very clear indications of those that would be seen as more appropriate for in-person and those that might be seen more appropriate for the flexibility of remote attendance. The giving of reasons we're hoping will explain to people sometimes, because what we've had, and I note the Scotland's responses in their recent consultation also report some feeling there's a lack of transparency and a lack of consistency of approach amongst different members of the bench. So it's that effort of trying, because open justice is not just, it's often paraphrased as the need for justice to be seen to be done, and to be seen to be done, it needs to be understood. Why did that happen and why didn't it? So it's trying to knit that together in relation to this opportunity to build upon what already existed.
Okay. Final question then is just, we appreciate that this is kind of almost there but not quite. There's still maybe a wee bit of finessing to do, so could you just maybe give us an indication as to what you're still looking at and what you're still finessing?
Okay. A letter went off yesterday to Parliamentary Council on another draft. In fact, there's one of the finessing concerns the new offences that have been created, which are J907 and 908, but it's actually only one tiny subsection in relation to it. And when I say that, though, that's not to imply that it isn't complicated and technical for what we're asking for the drafts on then to do. So that's one area. We don't think it's exactly right. It's pretty much there. There's a little tweak being sought in relation to who needs to be seen and heard and who has to be seen and heard, and who should not be seen and heard at any stage, even if they're observing or participating. There's not much else in relation to it. We do have an exercise, however, to conduct, because the new provision, which I just mentioned, the J902A, is something that happened post-consultation, is occurring in Scotland, but has had very beneficial and no opposition to it being extended. And this is a very limited assumption being made in law that where the person is public authority and it's a single party proceeding, and that single party proceeding really means where there's not a requirement to serve notice on anybody or something like search warrants, financial restriction on somebody's accounts, because if you told them beforehand it would be gone. In other words, it's based on existing law, but it's only for those what the lawyers would call ex parte. Layman might just say without notice. So they're quite restricted. Now we have just taken a power in relation to that. We need to reach out to see who are the people not in the justice field who might feel they could have use of that power. And the reason for it is that Scottish Police gave some responses, and recently in the most recent extension, and the number and costs that were being saved by the being able to use that ex parte, they were quite considerable. I can give it back. I just don't know where's my paper if you're interested. But and that with our own budgetary constraints our pressures on our police forces, and I'm sure anybody who's seen when you've considered the statutory rules, the explanatory memorandum points out the benefits that have been for being able to attend remotely in a case that's appropriate, and being able to continue doing work and not being lost because you're hanging around the court, and another person's had to go with you as well.
Yeah, of course. I mean, it's a no-brainer, so no, that's helpful. Yeah. But with that on board, we're still roughly on time, are we?
Oh yeah, that will be there at the call for the call of evidence. Sorry, I just lost my pen.
We'll have that revised version with you at the tail end of next week.
Perfect. That's lovely. Does anybody have anything else? No, we're all good. Folks, could I thank you very much? It's really helpful just to tease out some of these issues and understand kind of what your thinking is and the rationale behind it. Thank you very much. We appreciate your time today. Doubtless we'll see you again. I'm sure we'll have more queries, but that's all the joys of scrutiny. So thank you very much indeed.
Thank you. Thank you very much indeed.
All the best, folks. We'll plough on here while you're making your exits.
Thank you.
Members, so could I seek your agreement then that we note the papers from the department, and as we've agreed previously that we'll publish these papers on the committee's webpage? Members agreed? Agreed. Thank you. Agenda item 6 is the Justice Bill evidence from the Commissioner for Children and Young People. You'll see that the Children's Commissioner is unfortunately unwell and unable to attend today's evidence, so the committee staff are going to liaise with the Commissioner's office to rearrange the session to a suitable date in the work programme. Okay? Thank you. And we wish the Children's Commissioner a speedy recovery. Agenda item 7 then is Statutory Rule 2024-219, the Police Pensions Amendment Number 2 Regulations Northern Ireland 2024. I'd ask you to turn to page 143 of your meeting pack for the relevant papers. This rule is going to amend the Police Pensions Regulations 2015, which give effect to the Police Pension Scheme 2015, PPS 2015, including provision for the contributions payable by members of the scheme. The proposed regulations provide for the current contribution rates last applied for the scheme year ending 31st of March 2025 to be amended to address a 0.2% shortfall in the yield of employee contributions identified by the Government Actuary in the 2020 Police Pension Scheme valuation. The rule is subject to the negative regulation procedure, that's resolution procedure. The examiner hasn't raised any concerns regarding the technical aspects of the statutory rule in her report, and that was published on the 14th of January this year. So, members, just a reminder that the committee agreed that it was content with the proposal for the rule at its meeting of the 12th of December, and the department has confirmed that there hasn't been any change to the policy since the SL1 was considered by the committee. So, does anybody have any comments, or are you content with the statutory rule? Content, okay. If you're content, then I'm going to put the question. The question is that the Committee for Justice considered SR 2024-219, the Police Pensions Amendment Number 2 Regulations Northern Ireland 2024, and has no objection to the rule. Are members agreed? Agreed. Thank you.
Good.
Agenda item 8 is SR 2024-224, the Insolvency Amendment Rules Northern Ireland 2024, and it's page 162 of your pack. This rule is going to amend the Insolvency Rules Northern Ireland 1991 in relation to the financial limits for eligibility for the Northern Ireland Debt Relief Scheme. The maximum potential realisable value of domestic motor vehicle which must be disregarded for the purposes of determining the value of a person's property in connection with a debt relief order will increase from £2,000 to £4,000, and again this rule is subject to negative resolution procedure. Again, members, the Examiner's Statutory Rules has raised no concerns regarding the technical aspects of the rule in her latest report, which was the 14th of January. We agreed on the 27th of June at our meeting on that date that we were content with the proposal for the rule, and the Department has confirmed there's been no change to the policy content since the SL1 was considered. Do members have any comments, or are you content with the rule?
Content.
On that basis, I'm going to put the question that the Committee for Justice considered SR 2024-224, the Insolvency Amendment Rules Northern Ireland 2024, and has no objection to the rule. Are members agreed?
Great.
Thank you. Agenda item 9 is an SL1, which is Electronic Monitoring Requirements, Responsible Officer Amendment Order, Northern Ireland 2025, and I would ask you to turn to page 172 of your pack. The Department's proposing to bring forward a statutory rule to authorise the organisations providing electronic monitoring services in Northern Ireland. The regulations require that whichever organisation carries out this monitoring be designated in law as responsible officers before they can deliver electronic monitoring. A new service provider will be formally awarded the contract at the end of January following an open procurement competition. It's proposed that the rule will be subject to the negative resolution procedure. Deirdre.
It's just looking more information, because I know the last time, I mean, obviously these issues come up in communities in terms of how the contract's being managed, and particularly around tagging and their conditions, and are they being monitored closely enough. So I'd be keen just to see did anybody else apply, and particularly those who currently hold the contract, and did they just not meet the threshold. The other bit is around, obviously, it's a new company. From my understanding, it looks like they're based in England, but are they going to have a physical presence here? I'd be keen just to see that, to get an update in terms of, and will that offer employment opportunities for people here? So what way are they going to actually operate going forward? And then the other bit, now I might not need all this in terms of agreeing the SL1, it's just for additional information, because it is an issue that we would get on a regular basis in terms of operating the tagging. And then just how that's the issue of monitoring in terms of the contractual commitments, or how it's built into the contract. Just more information on how that's going to be done by the department, you know, to ensure that those who are tagged and being monitored, that is actually being done.
Yes, good points. I have a few myself, and I think we will wait for them before we agree. I think we need to have some understanding here. So the questions that I had also were, okay, well, what was the reason for the change? You know, so that we have some idea as to what was behind this. How often, in general, is the contract reviewed and changed? Is there a review of performance built in? Are there any other changes about which, well, just are there any other changes? And will there be any differences in monitoring? So just to give us some understanding as to what the proposals. I mean, look, I'm acutely conscious, and there's a lot of discussion at the chairperson's liaison group about SL1s. This is legislation too, so we can't just, I mean, if there's things we need to know and understand, then we should ask, because once the department lays it, there's no going back. So we're better to tease out the issues that we have now and understand what we're agreeing to. We don't always need to, but sometimes we do. And I just want to have some understanding around this contract and what it means. So are members content that we would seek answers to those questions that have been raised by Deirdre and I? Yep. And hold on our approval until then, just to see what's going on in the background? Thank you. Agenda item 10 then is correspondence. There's a correspondence memo and 9 items of correspondence at pages 179 to 286. I'm going to draw your attention to a couple of the items, as I usually do, and then I'll open the floor for anybody who's got comment or issues they want to raise. The first one I'm going to draw your attention to is item 10.2, which is correspondence from the Minister of Justice at page 182. That advises that the UK government that the government is intending to bring forward a crime and policing bill, which is likely to contain measures that apply to Northern Ireland. We're seeking your agreement to ask the Department for information on the measures it anticipates are likely to be included in that bill, and a clear indication of the time frame for the bill's expected introduction at Westminster. Are members agreed? Agreed. Thank you. Item 10.5 refers to correspondence from the DOJ at pages 194 to 247, and that's a response to requests for more information on trauma-informed practice. Also, there was a lot of stuff there that was attached in the committee post box, wasn't it? Yeah. Yes. Does anybody have any interest in this kind of training, in this workshop? It's going to be 2.5 hours. If anybody does, I do. I like the look of it. I think it would be helpful. but I'm wondering maybe we should check is the best way to do this through the Member Development Programme, you know, CAMS, and whether or not these folks have touched base there. So maybe, Kathy, we could ask you to have a look into that and maybe refer them to there. It might be the best way to take it forward if they're planning to open this to all members.
Agreed.
Members agreed, yes?
Yep.
Thank you. And then again, I've said yes, there was considerable volume of stuff attached to that, so it's all in your post box if anybody wants to look at that. It was put in there Tuesday. Are members content to note those items that have been in the post box?
Noted.
Thank you. Item 10.10 then is correspondence from the Committee for Finance regarding the draft budget for 2025-26 and the budget sustainability plan. Are members agreed to note this?
Noted.
Thank you, because while formal notification hasn't yet been received, the Committee for Finance is expected to request that, and it's not as if we don't know anybody who's on that committee, but they're expected to request committee responses to the 25-26 budget are provided by the end of February. So based on that, officials are going to provide us with oral evidence on the draft budget for the DOJ at our meeting on the 6th of February. Okay?
Yeah.
And that'll give us a bit of time then to collate our thoughts and feed those in. The committee may want to ask the Policing Board and the PSNI for views on the PSNI budget position, given that it accounts for such a significant proportion of the Department of Justice's budget. We may also wish to request the views of the Department's other non-departmental public bodies on their indicative allocations. Does anybody have any views on that, or are you happy to request those views, Deirdre?
Yeah, no, I think it'd be good. And then also, obviously, the issue that's coming up is around the national insurance increases. I know the Finance Minister was at the NI Select Committee yesterday and just saying that we could be potentially still 100 million short, because obviously the government are saying they're going to contribute so much and about it consequential, but she's saying it's going to be nowhere near enough. So I suppose from my point of view, and this doesn't extend the arm's length bodies, so it'd be keen as part of that budget briefing what impact that increase in national insurance will have on the department, on the arm's length bodies. And then I know it's a concern that has been raised in terms of the impact of the voluntary and community sector, who normally are contracted through grants. So is the department looking at that? And the Labour government are saying they're not making any kind of financial contribution to the voluntary and community sector. So could DOJ in this instance, look at flexibility in funding that would allow organisations to maybe move budget headings to try and take on some of these additional costs? Or is there the potential, I think, just to get a sense, or are there risks for the department? So I think it would be good to look at that, because it is big numbers that we're kind of looking at. So that would be good to get that briefing as part of the budget.
Sure. Members content? Yep, agreed to do that. Lovely. Ciara, you had something?
I was just in relation to, it was page 273, and it was a correspondence from the Chair of the Health Committee to yourselves, particularly around, obviously, the controllership framework. I have, and we've all, and probably have all met Alma from Caleb's Cause, who is having his fantastic ambassador, and it's an amazing campaign that herself and many other families are having to support our children post-19 and special educational needs. Over the years, I've met with many a family where they've had difficulties, and particularly around the whole financial side of stuff and the personal affairs of their loved one or their young person. So I would be interested from a department point of view, probably having information more about what is the current controllership process, what is the framework, is there guidance for parents, because it seems that parents do struggle, and it's quite expensive process as well, and that shouldn't be the case. It should be quite clear, and I know Scotland has improved around guardianship, etc. So if the department maybe could provide us more information on the current structure around the controllership process, the current scheme, the framework, the guidance. When was there a review? When's the last time there has been a review of it? I think that's, and any comparatives. I think it would be really useful to know. And is there any plans by the department to look at it and to improve the controllership framework that currently exists for parents and their loved ones?
Fair enough, members agreed.
Okay.
Thank you. Anybody else have anything in correspondence? I have one which it relates to the sickness stuff. You'll recall on the back of the report that came in that was it Nisra, I think, the DOJ was the worst in terms of sickness absence, was the worst department, and we had asked, okay, well, what's going on in the background, what are you trying to do to alleviate that? So we got some answers. I just have a query with one of them, which is they're saying there, page 249, which is the third bullet point, embedding equality, diversity and inclusion, providing a clear rationale and case for change. I suppose it's to understand how DEI is linked to sickness, and what change, whenever they refer there to the case for change, what are they talking about? To what are they referring? What is the case for change? Also interestingly, Doug, I'm sure you spotted this too, the talk then about the prison service and what's going on in there and what they're having to do with that, but and the additional support that they're providing, and yet not in the handbook. Anyway, so would members be okay if we asked that question about sickness?
Yep.
Thank you. That's all I have in correspondence. Nobody else has anything? Agenda item 11 is the forward work programme. That's at page 288. So that's going to be amended to include an oral evidence session on the draft budget on the 6th of February. So the oral evidence from the Law Society is going to be rescheduled. Okay? So obviously, can I seek your agreement that we proceed with the evidence sessions as set out in the draft forward work programme, subject to changes as agreed during today's meeting, and obviously allowing us to build in some degree of flexibility where it's necessary? Yes?
Great.
Thank you. Agenda item 12 is chairperson's business. I have one issue. The Police Federation are seeking to hold an event to launch a campaign about assaults on officers. It's later on in the year, but they've asked me to sponsor that, not in my capacity as an MLA, but in my capacity as chair of the Justice Committee. So I want to do that and seek your permission that I can do that. I don't know, that's the level of detail that I have. I think they want to be able to refer to me as the chair of the Justice Committee. In circumstances, for example, where I'm sure this will not be the only time we'll get requests like this for each of us, but were I to be invited to speak or something like this, my intention would be to handle it as we do in debates, where things are within the committee's remit, and with the committee's agreement I'll say it. Where it's a party political point of view, it'd be very expressly clear that this is not a committee position, it's a party position. That would be how I would intend to handle anything like this going forward. But I wanted to seek your agreement, whether or not you're content that I can, as Chair of Justice, sponsor this event. The rules are the same. You know, you just go out and get other members, but in my role as Chair, I wanted to put it to the committee. Justin?
Chair, thanks. You should not be marginalised as chair of the committee for hosting an event for the Police Federation.
Thank you. So you're all content that I work away then?
Great.
Yep. Thank you very much. I appreciate that. Any other business? I've one issue. Do you have one?
No.
You'll recall in the course of the debate when we were debating transgender prison housing policy that the Minister indicated that nobody had gone to the library to seek the guidance. There's a lot of stuff that comes to this committee that we don't need to ask for, it just comes. However, if we need to ask for it, then we'll ask for it, that's fine. Our members agreed that we could write to the department and ask for the instructions that were given to prison governors with regard to the handling of transgender prisoners, just so that we know what was put out there.
Yeah, for information.
That's great. Yeah, that's perfect. That's all I needed. Date, time, place of next meeting, that's going to be next week, which is Thursday the 30th, 2 p.m. in this room. Members, thank you very much indeed. Much appreciated.
No.
Committee Room 30, Sound.